First, I want to sort of turn to Sarah and Dustin, and can you describe a little bit about, we have discussion about how the law looks and what the books say about how Class C tickets are handled, but when you get into the counties where you see these cases handled, the procedures in court differ from county to county. And so I wanted to hear from you all about some of your experience with that and what a child's experience is like going through those courts and how that contrasts maybe with the juvenile justice.
There are 16 justice of peace courts here in Harris County, and there are about 16 different ways to handle these cases. We have some courts where you literally never see a judge. The cases are being handled by court staff, or cases may be handled by the prosecutor's office, which here is the Harris County District Attorney's office. Probably about 50% of the cases, the parents are given warnings and information is provided about the effect of a conviction. The other 50% of the cases don't get any type of warrant. And actually, I heard of one case, and I think RJ may have been there, where the parent and child went up to a window and talked to a clerk and gave a plea. And if they pled guilty, then the clerk took care of the paperwork and the fine and everything. They pled not guilty. Then they were moved to another docket. And in most of our cases, we file a notice to the court to let them know that the parents have an attorney. And in those cases, the cases are actually moved to a separate docket so that the attorney can deal with another attorney. And I find that very interesting in terms of this whole backward kind of thing about these tickets in general. You would think that the parents really need to interact with somebody if they're not represented. And the opposite is actually.
What's the general expectation rather than sort of coming up to a clerk and pleading guilty to an offense? What would the general expectation be for a child in that situation? I mean, would it be, what sort of process has been denied?
The biggest difference that sticks out is in the juvenile system. Before you would have ever gone to court, you would have met with juvenile probation, been assessed to see what your needs are. You would also, before ever entering a plea, hopefully speak to your lawyer who would look at the facts of the case and the complaint and would analyze them against the provisions of the law that you're accused of violating. So of course here we have unrepresented children in the vast majority of cases going before adult courts where the judge may not even be a lawyer, and they're certainly not given one. So there may not be anyone in the court besides the prosecutor who's actually aware of the elements of the crime that the juvenile is accused of violating. So they have no informed decision, to base their decision on whether to plead guilty or not. Additionally, I work at a disability rights organization, and in family court, if we were in a juvenile setting, you have Chapter 55 of the Family Code that protects people with mental health issues and people with developmental disabilities so that you can request an assessment to see if you're actually fit to proceed, if you can understand the nature of the crime you're accused of, participate in your defense. Of course, people in JP and municipal courts have usually not ever heard of any such protections, and if you ask for them, they're unaware of how they would ever assess such an individual. And usually, I've even had it suggested that a parent can make a plea for a young man with autism who doesn't have words to communicate, and of course, that's not how our criminal system works either. So it really is a farce.
So, Kathryn, I have a question for you. You all really have researched this issue quite extensively, and in reading your report, one of the barriers to this is collecting good data. We have estimates, but I wonder if you can talk a little bit about that and about sort of how the lack of transparency and understanding the number of kids who've been ticketed really affects those children's experience.
I think it affects those children's experiences, and then it affects the ability to make good public policy, because we really have no idea what these kids are being ticketed for. In some jurisdictions, kids will get tickets that just say disruption of class, but there will be no incident report, what exactly happened. And so there's this kind of mentality that these are horrible kids and that they're getting in serious fights, and we have really no idea what's going on because there's no kind of uniform data collection. There's no one agency or one entity. In some school districts, they contract with the municipal police department, so no one is keeping track, and they just know by the address that this was a school-based ticket, but there's really not a sense of what's really kind of going on with these kids or the incident that occurred.
What's the impetus here? I mean, what do you understand from your experiences as why we've seen this increase so much, and what's happening at the school, sort of on the ground, that has really led to the reliance on classic ticketing?
I want to look at the practical impact. We put law enforcement into schools because we were afraid. And law enforcement in schools means that they come into more contact with a student on any given day. So I like to think of it as, if I had a police officer following me around every day as I'm driving, at some point I'm going to get a ticket for failure to stop or for passing the speed limit, just because of that connection and that exposure. And then I think it became a vicious cycle because the number of tickets increased, so we put in more law enforcement, and so what happens? More tickets. And so you know, we have to look at it as a practical matter. The other thing that's of particular interest to us at the Earl Carl Institute, we are affiliated with Thurgood Marshall School of Law on the campus of Texas Southern University. And so most of you know that we're historically black university. And one of the problems here, which is a problem throughout the criminal justice system, there are biases. There are situations that appear to be race neutral, but the result is a disproportionate impact on minorities. And so you have law enforcement who are applying law enforcement standards, who are bringing the same kind of biases into the school. And what you find is African American, especially male, and to a slightly more lower extent, Hispanics are disproportionately impacted, to the point where in some school districts they receive twice the number of tickets as their population in the school. And the reason that is incredulous is because, as RJ said, 97% of these tickets are discretionary. So we're using these tickets in a manner that's affecting individuals who have disabilities and minorities. And we are saying we want law enforcement to take care of our kids as opposed to another system, as opposed to the experts, the social workers, the educators. That's the big problem.
Dustin, the same is true for special education students, correct? That they're generally disproportionately represented?
Absolutely, and one of the interesting things is for special education students, you do have some rights under federal law. The Individuals with Disabilities Education Act actually gives special education students a right to an education that's individually designed to meet their needs, which can include an education that's designed to offer positive behavior supports and interventions to help a student improve their behavior. And unfortunately, I think in some cases what we're seeing is students being ticketed as a way to circumvent responsibilities under federal law to provide that individualized education that meets the student's needs. And the procedure that practically does that is you have a special education student that you represent or know, and they're having one-to-one behavioral problems in school. You would actually request that a research professional conduct a functional behavioral assessment. Then you would go to the ARD committee that makes all of the decisions about that student's behavior. You would review that assessment and you would implement a behavior intervention plan that's designed to make actual improvements on their behavior. In many cases, I think schools are not making use of board-certified behavior analysts and other professionals who are really aware of how to come in and make valid recommendations for how to change a student's conduct and implementing those plans. And sometimes it's because they don't know or because resources are short, but it's also because they're spending their money instead on criminalizing students.
Right.
If I could share a case.
Sure, of course.
We recently represented a student, and we worked with Disability Rights Texas. This student came to us because the judge had ordered that he drop out of school and get his GED. Unfortunately, that wasn't a practical solution. He was functioning on a 4th grade level. He was 17 and in the 9th grade. Also, in the course of our representation, we found out that the judge had issued warrants, 2 warrants to be exact, that have been picked up for failing to pay fines from previous conviction. And so we worked with Disability Rights Texas and filed a motion to modify the conviction and asserted that the student was entitled to his rights under federal law. School hadn't provided it. And we had the warrants lifted because both the student and his father were indigent. They both received Social Security disability. And you're not supposed to arrest somebody just because they can't pay a fine. So we filed the documents with the court, and what ultimately happened was we went to court to have these matters heard. And as a courtesy, attorneys are generally called first on the docket so we can get in and out. Not only was I not called first, I was called last. You're not supposed to file that kind of paperwork in these courts. I asked for professional courtesy, and the staff said they were directed by the judge to make me wait. So we did that. We ended up getting the GED changed in school back, the child back in school with the supports that he needed. But it can be really an uphill battle, and the courts don't understand the disabilities. They don't want to understand the disabilities. And the other thing that case taught me is that if the school wants to get rid of a child, this is how they do it. Because the professionals who were involved, including the school truancy officer, acknowledged that the school did not want the child back and was directing the judge's staff not to allow the child back. And we just gently reminded them that this is not a school's decision. But these cases can be very complicated and very heartbreaking.
So what that kind of begs for me is, what really is the role of the JP and municipal courts in terms of the cases they hear? I mean, in terms of the contrast between the juvenile justice system and JP and municipal courts and their roles, I mean, it feels like the JP courts, really their job in the municipal courts is to get through their docket, right? And I wonder, is that what we're talking about? Does that impact the students' participation in that process and sort of implicate their rights?
I think that they're trying to, like you said, get through their dockets. I think that in a lot of municipalities, they don't have the resources that where they could have a case manager in the same way you would have in a juvenile court to kind of work with the family and see what the issue is. A lot of the cases we hear with like truancy, we hear from parents that it's, there was an illness, the mom was ill and couldn't get her kid to school, or there's transportation issues, something that if someone at the school had just asked, could have easily been dealt with and didn't require a court referral. And so, but there's no one at the school to do that because we're not funding our schools, and there's no one at the court to do that. And so we end up putting these kids in this situation, and I think it's just not a place for children in this kind of misbehavior.
Right.
I'd like to add on to that too, because I couldn't agree more. And it was interesting this morning to hear the chief talk about that strong correlation between truancy and then later criminal involvement. And of course, we understand that many of the students we represent practically need a lot of help. And that is the primary reason, in my view, that this is such an inappropriate way to handle them. Think about how ironic it is that the way we handle not going to school is to require you to miss school and go to court, right? We have a real concern that you're not going to school, so please miss all day tomorrow and come to court. And not all municipal and JP judges are equally inappropriate for kids. There is a spectrum out there because courts, like Sarah said, vary so much. I've had the interesting experience of having represented kids as far away as El Paso, because I represent a lot of foster youth who end up in different parts of the state, as well as kids here in the Houston area. I've been to courts where I've heard complaints that the judge has personally spanked students as a punishment in a Class C misdemeanor case. Again, remember, these are not lawyers, right? It's just anyone that is able to win the spot for JP or municipal court judge. And then here locally, Judge Faraga in the municipal court does a great thing by holding his docket in the evening, which I think is very, very rare. I've never seen another judge in Texas do it, but it at least keeps kids from missing school. So there are practices that vary, but overall these courts are completely inappropriate from a policy point of view for handling children because they just don't offer services.
I just want to share another kind of interesting case. about the inappropriateness and judges not understanding some of the key issues here, because often our kids, in cases other than fighting, do have some sort of mental illness. And we had a child with severe mental illness. His mother went to court and tried to explain to the judge what his mental illness was, how he manifests his mental illness in his behaviors. And the judge said, well, I'll tell you what kind of therapy I believe in. I believe in, I'm gonna send your ass to jail. That's my kind of therapy. And he repeated that about 3 times. And the child
was there for the
was
first
there.
swearing?
Yeah, and the charge against the child was profanity.
Right. So this all kind of begs a question, right? And that's that. I mean, school discipline obviously is an issue, and we need good forms of discipline. Schools suffered some pretty incredibly devastating cuts in the last legislative session. A lot of the tougher schools have younger teachers, maybe who aren't as experienced with how to handle the tough kids. So the question that we get asked about this is, if not ticketing, then what? And what do we need to look at then? If ticketing is one of the tools that they've got in their toolbox for discipline, then what do we say? How do we say to them, we're going to take it away?
The Department of Education has a great website in promoting what is the research-based practice in school discipline, which is positive behavior supports and interventions. And the website's pbis.gov. So if you want to learn more about what PBIS looks like, check out pbis.gov. But really what we want is policies that are research-based and peer-reviewed, as the No Child Left Behind law mandates. And in discipline, that's positive behavior supports and interventions. We need a lot more training of school staff. We need policies that reflect that. You know, when we think of some key principles about discipline policies that work, I think for parents in the room, it's not going to surprise you that it helps if the student understands what they're being disciplined for, if the punishment is close in time, if it's related to the misbehavior. I mean, those are all kind of common sense practices. But when you think about ticketing, it just doesn't follow any of those, right? Your court date is several months from the time of your misbehavior. An average client of mine can probably not recall to talk to me about the day that they are being disciplined for. It's a process that the student does not understand. It's a consequence that is largely a fine paid for by a parent or not, but not a consequence that's meaningfully related to what they did in a way that they can comprehend. So there's nothing that's consistent with common sense or research in how ticketing would be a successful strategy in correcting student misbehavior. And so, you know, we know what those strategies are, we kind of know what they look like, and there really is no substitute for the people who are involved with that student on a day in, day out basis, figuring out why they're misbehaving. Students with disabilities are largely misbehaving to communicate something, right? You know, if you have a communication disorder in particular, you know, your misbehavior, you throwing that chair, you saying that cuss word, what it is, you're trying to say something, and we don't get to the heart of what it is you're trying to communicate and provide you with the tools to replace that inappropriate communication with something that's appropriate, we're never going to see improvements, and we're certainly not going to see it by sending you to court.
So I have, so just 2 things to kind of piggyback on what he said about PBIS. One of the reasons why it's like a best practice is it's about teaching kids the proper way to behave before they misbehave, which again for parents, I know like you give your kids rules up front in advance, like when we go out in public, this is how we behave, and that's part of the model is kids know what the expectations are, they know what standard they have to meet. And one of the other things Appleseed is advocating for is a couple of jurisdictions, one in Georgia and a couple in the Alabama area, have gone to a kind of a graduated sanctions model. So for kind of low level, like disruption of class, disorderly conduct type offenses, which is, you know, throwing an eraser or something at the teacher, that they would handle that internally at the school first. On the first offense, you would get some kind of warning. On the second offense, you would maybe stay after school and do like a behavior class. And then only on the third offense would you be referred to court, because at that point, the school has shown that they've done as much as they could do to intervene and get you on the right path before they send you to court. And what we're seeing with ticketing is that, I mean, that's like your first time you say that cuss word, you're getting a ticket and you're being referred to DAAP, and there's no kind of step up process to what is a very serious consequence.
And I was just going to add that in our cases, and I would invite you to look at the materials behind tab E, you'll see information about our representation and an excellent article that was put together by Disability Rights Texas. But we provide representation to students in these cases and have no income guidelines, so we have provided representation along a number of socioeconomic variables. And I would say between 80 and 90% of our cases, the kids have already gotten a ticket before. The ticketing is not affected. I know there was a recent report that came out that says ticketing is not affected. I talked to a child a couple of weeks ago and I asked, is this your first ticket? She said, no. I said, the first one didn't work. She said, it's just a ticket. The child doesn't know. The parents don't understand. And then the other thing I'd like to share with you all is that in about 40% of the cases that we've handled over the last year, about 40% of those cases were dismissed outright without any fines, without any costs, without any community service, plea of not guilty, and then a subsequent dismissal. And so that tells us a lot about whether or not the school really needs this kind of mechanism to handle the majority of their students. So I had a question.
Yeah, I'm curious to know if you guys have done research on the number of public schools versus the number of charter schools. Are you using ticketing as a defense mechanism? Because I know I work at a charter school and I'm a teacher, and I know that that's not even, like, we don't have, like, oh, have that right, but I know our principal does everything within their means to, like, before we even get, read the history, we've never done it. So I'm wondering if you guys have done a research of, like, just public schools versus charter schools, and, like, what are some patterns that we're seeing, or maybe, like, using, what are some of the disciplinary actions that charter schools are using versus, like, public schools, where this is?
You know, I can't call it research, but what I can say is that every Monday across the state, all of our education staff review every request for assistance that comes in to our office. We're a statewide organization and receive, you know, up to 100 usually requests for assistance per week during the busy parts of the school year, just on education-related cases. And I can't recall a ticketing case in a charter school. I do, however, get complaints constantly about charter schools excluding kids with serious behavioral problems and disabilities. You know, the most common complaint we get about a charter school is they say they can't serve special education students. They say if they handle special education students, they're only going to take a kid with a learning disability, not a kid with an emotional disturbance. Or they threaten that if I don't disenroll my student, that they are going to expel them and then they won't be able to get into another school. Like really aggressive, subversive tactics for keeping my kids out of the school at all. So I see different complaints. You know, I mean, I think the ticketing problem is pervasive in the public schools, but I kind of worry that my clients just aren't allowed in the charters at all.
You know, we're moving into the next legislative session. We saw some activity in the last legislative session. I mentioned that. Here we are at a policy event. What would you all recommend going into the next session as ways to deal with this issue? You know,
I would like to see some offenses that are very school specific be completely removed from the education code, because I think it just creates kind of an encouragement to use ticketing as a first resort. So I see no reason that disruption of class, disruption of transportation, and disruption of school activities even exist as criminal citations. All of those behaviors could be dealt with under existing provisions of the penal code if they really did rise to that level where that needed to occur. So that's one thing I would suggest.
One of our biggest things is the data collection, is getting better data so we have a better sense of what's going on for advocacy purposes. And then the other thing is training for school police officers. You're not on the street, so you shouldn't be acting like you're on the street. You should act like you're dealing with children who are still learning and still developing. And so one of the big things we're advocating for is for school-based police officers to do training, kind of de-escalation, behavioral intervention, best practices, recognizing kids with disabilities, like when they're acting out in a relation to their disabilities, and some of those kinds of trainings that they are not required to do as like a regular street cop. But those are the kind of big things for us.
We're really advocating the use of positive behavior interventions. And I'll just close with this one more story.
Yeah, great.
That's what lawyers like to do, right? But yesterday we received a phone call from a parent that one of our students had tried to commit suicide. And we met with that student a little over a week ago. And during the course of the discussions, it became very clear that he was crying out for help. He's crying out for help from the school, from his mother, from everybody. And we told him that we were going to help him because the path he was on was leading him straight to prison. And we didn't want to see him go to prison. When he left our office, he hugged us. And there was 3 of us involved, and we all were very touched. And it was devastating to find out he had attempted suicide. But I think it just reinforces the point that law enforcement is not the answer. And so whatever we do, whatever we advocate, we need to put it in the hands of people who can actually hear these cries for help and make a difference.